Hey, everybody, welcome to the Let's Talk Live podcast. This is episode 13, and it's June 24th, 2023. There's been a lot of new documents that have been dumped in the Bryan Kohberger case, and one of the documents that has brought up some recent controversy in the media and across the YouTube platform has been a document of a motion for protective order. What I want to do today is kind of take you through a guided tour of that document and give you some insight as to what may be happening. Now, again, I want to start this off. I am not a lawyer. I am not anybody that is an expert in DNA. I have no affiliation with law enforcement. I'm just giving you my basic overall opinion. So there was a headline that came out the other day, and it said DNA from cheek swab of man charged with the slaying of the 4 Idaho University students last year has been found to be a statistical match to that found on the knife sheath at the crime scene, according to new court filing. And of course, the document that we're going to talk today is the motion for protective order. Let me take you through some of the document here. We'll read through this, and I have some kind of highlighted points throughout this presentation to kind of give you a guided tour of, what possibly could be going on. Also, you're going to notice that I'm going to reference in Peter Tragos. He has a channel called The Lawyer You Know, and just to kind of get some insight, because again, I'm not a lawyer, and if I can have some, person that is an expert in the law reading these documents, maybe we can get a little bit more clarity as to what's going on. So the document starts, it comes now the state of Idaho by the through and Latah County prosecuting attorney and respectively moves the court for a protection order pursuant to IRC 16-1 for the information related to investigation genetic genealogy. This case arises from a quadruple homicide. Law enforcement found the DNA of potential suspect at the crime scene, and the FBI submitted the DNA to one or more publicly available genetic genealogy services to determine potential relatives of the suspect. The FBI then used common genealogy techniques to develop a family tree leading to the defendant. The state seeks to protect from disclosure the names and personal information of hundreds of innocent relatives on the family tree, the names of the publicly available genetic genealogy services used, and certain other information described below. This disclosure of information is required by Rule 16 of the Idaho Criminal Rules and should be protected from disclosure for the good cause described below, including the state's privilege to protect the identity of the informers as described in Idaho Rule of Evidence 509. So on November 13, 2022, law enforcement found the bodies of Madison Mogen, Kaylee Goncalves, Xana Kernodle, and Ethan Chapin at 1122 King Road in Moscow, Idaho. All 4 victims died from apparent knife wounds. Law enforcement found a K-bar knife sheath on a bed next to the bodies of Madison and Kaylee. The sheath was face down and partially under Madison's body and the comforter on the bed. Law enforcement seized the K-bar knife sheath pursuant to a search warrant. The Idaho State Police Lab in Meriden, Idaho, located the DNA on the knife sheath. The ISP laboratory determined the DNA came from a single source and that the source was male. So that's giving you a little bit of a background as to where this knife sheath was found and how this DNA was discovered. So let's see what Peter Tragos has to say here, what's going on here in this document.
Let's get a factual background. How did we get here? How is the DNA relevant? I hope they answer those questions for us. On November 13th, 2022, law enforcement found the bodies of Madison Mogen, Kaylee Goncalves, Xana Kernodle, and Ethan Chapin at 1122 King Road in Moscow, Idaho. All 4 victims passed from apparent knife wounds. Law enforcement found a K-bar knife sheath on a bed next to Madison and Kaylee. So the sheath was on a bed next to 2 of the victims. The sheath was face down and partially under Madison and the comforter on the bed. To me, this seems like new details. I don't know. Maybe this was described in this detail before, but it's clear They found the sheath there. They found it next to the crime. They found it at the scene. And for the first time, we maybe realize how this happened. How did whoever did this, whether it's Bryan Kohberger or the defendant, how did they leave the sheath behind? It made no sense. Did they do it on purpose? Were they framing Bryan Kohberger? Did Bryan Kohberger, if it wasn't him, if it was him, did he want to get caught? Is this part of an experiment? But we kind of get an idea. They can't use 23andMe by law, Ashley Oak said. I was just kidding. But did he drop it? Did it come off the knife? Whoever did this, and then it got underneath the body in the comforter, and therefore you couldn't see it on your way out? Kind of seems like at least some logical reasoning as to why somebody that turned off their phone and did all this other stuff they're saying Kohberger did, but then left the sheath there with his DNA on it.
Okay, so that was Peter piping in here about what potentially could have happened or what went on that evening. And I want everybody to kind of remember this because there's been some new recent document dumps, kind of a defense response to this document here. And we're going to get more into that during this week. So we'll move on in this presentation here. So some interesting points that are going to come up in this next section of the document is STR DNA and SNAP DNA. And what I did was I went down and clipped out kind of the cliff notes at the bottom of the document so we could kind of widen them and look at what they're actually talking about. And you'll see these numbers throughout the document where they're referencing. So what is STR and SNAP DNA? While an STR DNA analysis involves looking at 20 regions within a human DNA, a SNAP profile contains about 650,000 of the hormone genomes, 3 billion nucleotides. I hope I said that word correctly. I know, again, I'm not a DNA expert. Someone will probably correct me down in the comments below, but I'll try my best here. Again, I'm not a DNA expert or a legal scholar, so we'll keep moving on here. And we come back to what is STR and SNAP DNA. So why DNA testing is used to research male ancestry, but there are two kinds of Y DNA, test SNAP DNA and STR DNA, which have different uses and purposes in DNA testing. What is STR DNA? Well, short tandem repeats, STRs, measure the number of times a sequence of genetic code is repeated at the specific location on the Y chromosome. The common STR DNA tests available are on 37 or 111 markers. Since the values for these markers change over time, they're useful for establishing a time frame when two men shared a common paternal ancestor. STR DNA is tested with a standard Y DNA test. What are the pros and cons of STR DNA? The pros of an STR DNA test is that it can be used to find your genetic family surname and may suggest what haplogroup and subgroup you belong to. And again, I'm not a legal expert or DNA expert. I'm probably going to get some of these names wrong, and I apologize. The cons are the unstable markers and the fact that it cannot define precisely when your most recent common ancestor with your matches lived. And we'll move on. So what is SNAP DNA? The single nucleotide polymorphosis, SNAP, is a mutation in one of the nucleotide base that are building blocks of our DNA code. Unlike STR DNA, SNAP DNA is very stable over many generations. When a mutation does occur, it is carried identifiably by descendants of the individual in whom SNAP was formed. A SNAP progenitor, this makes SNAP DNA testing particularly useful for distinguishing one genetic lineage from another. SNAP DNA tests are special tests that you can take after a Y DNA test. SNAP DNA tests are available as single SNAP test. SNAP packs or next generation sequencing, NGS testing, such as family trees DNA, Big Y 700, which does not come cheap at $449 or $279 for existing users. SNAP packs only test a limited number of SNAP. In its most case, they will be SNAP that were not formed recently. What are the pros and cons of SNAP DNA? The pros of SNAP DNA test are the stable markers and increased accuracy in identifying the most recent common ancestors with your distant family. The cons are that SNAP DNA test is more expensive than STR DNA testing. So you're probably asking yourself, what the hell does all this mean? So what is the difference between STR and SNAP DNA? I explained that STR, in short tandem repeat, is a different kind of mutation than a SNAP or single nucleotide polymorphosis. STRs are usually genealogically to determine whom you match with within a recent time frame of, say, the past 500 years or so. And SNAP defines haplogroups, and SNAP defines haplogroups which reach much further back in time. So SNAP, under my understanding, is just going a lot deeper than STRs. Once law enforcement had a single source DNA from the K-bar knife sheath, conducted what is called a short tandem repeat STR analysis. STR DNA analysis involves looking at 20 regions within a human DNA and allows law enforcement to make a direct comparison between two STR DNA profiles. So we just kind of talked about that. Law enforcement submitted the STR DNA profile obtained by the K-bar knife sheath to the Combined DNA Index System, which is CODIS, a database of STR DNA profiles from convicted offenders, arrestees, and crime scene evidence to identify the source of the DNA. No match was found. So basically, they took this, they cross-referenced it into CODIS, which would say, has this DNA or this person been involved in any other crimes before the crime that they're being accused of now? No, there was no matches that came up that we know of so far. Unable to find a match using STR DNA analysis, law enforcement decided to use investigative genetic genealogy to find a lead. Genetic genealogy allows individuals to trace their lineage or connect to unknown family members using DNA. Typically, that involves sending a DNA sample, which is a tube of saliva, to a genetic genealogy service like Ancestry.com or 23andMe. The genetic genealogy service then creates a single nucleotide polymorphosis, which is a SNAP profile, to use genealogic purposes. A SNAP profile is different than an STR DNA profile and is used more often for genealogy purposes. And that was, you kind of see that little circle there. That was kind of that cliff note that I had kind of blown up that was at the bottom of this document so we could read through that. And that's what that's referencing to in this paragraph. The genetic genealogy service then uses the algorithm to compare its users' SNAP profile and SNAP profiles submitted to the genetic genealogy service by other users to determine ancestry and potential relatives. The genetic genealogy service shares with the user a list of potential relatives and dependents on the specific genetic genealogy services. Personally, identifying information on those individuals, like their name, email address, and the amount of DNA the user shares with the potential relatives. The user does not receive any genetic information pertaining to other databases. Users' DNA profiles are not shared with each other. The same process used frequently by members of the public can also be used by law enforcement as part of their investigation, a technique referred to as investigative genetic genealogy, or IGG. Once a public available genetic genealogy service shows law enforcement potential relatives of a suspect, the law enforcement applies traditional investigation and genealogy methods to build a family tree in the effort to follow the tree of the suspect or close relatives of the suspect. Family tree can be used to narrow down a potential suspect based on factors such as age, gender, opportunity, and known physical, and we'll get to that. But right now I have another segment from Peter Tragos, the lawyer you know, that can kind of explain what's going on here. And basically what's going on is they're educating the judge or the jury as to how they found out and put all of this DNA and connected it to that knife sheath. So let's see what Peter has to say.
So what's interesting about this is they are using services that people use, and you're getting a little view into how lawyers sometimes have to educate judges. Whether they used Ancestry.com or 23andMe, it still helps in explaining to the judge what we're talking about. Because if you explain it with just the verbiage, the judge may be like, what are they talking about? But as soon as they say, oh, it's like 23andMe or Ancestry.com, the judge's like, oh, yeah, to see who your family tree is. And as technology advances, I mean, we are seeing cell phone data in every criminal case. We're seeing steps in every criminal case, location, every criminal case, even cars, the GMC or Teslas or whatever it is. You can see where it is, how fast it's going. Download the black box data. It wasn't long ago when, for our accident cases or wrongful death cases and trucking or whatever it may be, when we would go to download the black box data, that some cars just didn't have it. It's very unusual now for them not to have it. So as technology advances, there's going to be more evidence that the state is going to have to educate the judge and the jury on that are incredibly important. And that's going to be part of a lawyer's job.
Yeah. And I mean, I think Peter makes an excellent point here. I mean, a lot of this stuff I don't understand. I've learned just a lot, covering this case and reading about it. And again, I might not get all of the language out correctly. There's a lot of language that I don't understand, and I'm trying to understand, probably a lot like you out there as well. But, we can kind of piece all this together to try to educate ourselves and learn about this. That's what I like to do here is do those types of presentations. So let's move on here and see where we are in this document. So the IGG efforts, and this again is another highlight point that was below in the document on page 4, just kind of blew it up so we could read it and be a little bit easier for us to read. So for the ease of reference, this motion focuses on the FBI IGG efforts. The state is also seeking to protect the partial family tree created by the private lab, and it should be protected for some same reasons the FBI IGG efforts should be protected. So going into that next portion of the document, and you can see there where I circled that little cliff note or that highlight where it's pertaining to this portion of the document in this paragraph. So characteristics of the suspect. In this case, investigators use IGG to begin the process of developing a lead to the individual who left DNA on the K-bar knife sheath. The Idaho State Police utilized a private laboratory to develop a snap profile from the DNA on the K-bar knife sheath. The private laboratory started using genetic genealogy to develop a family tree, but after law enforcement decided the FBI would take over, the private laboratory ceased the efforts and sent the snap profile to the FBI. The FBI uploaded a snap profile to use one of more publicly available GG services. I'm just going to say GG from now on so I don't get tongue twisted. GG services to identify possible family members of the suspect based on shared genetic data. The FBI could then view through the GG service portal information regarding potential relatives of the suspect who left DNA on the K-bar knife sheath based on information the FBI could see in the GG service portal. The FBI went to work building a family tree of the genetic relatives to the suspect DNA left at the crime scene in the attempt to identify the contributor of the unknown DNA. The FBI built the family tree using the same tools and methods used by members of the public who wished to learn more about their ancestors. For example, the FBI consulted social media, viewed vital records such as birth and death certificates, and viewed other information already contained in the user portal for the GG service, including unverified information submitted by other users of GG services. The FBI also consulted subscription-based databases available to law enforcement for information on, and I'm going to do another highlight here, and this is on the page 5 of the document. You'll see this, I circled it. So STR DNA analysis has been used in criminal cases for inculpatory purposes for more than 20 years, and it's referencing a case, United States versus Beasley. We believe the reliability of the PCR, STR method of DNA analysis is sufficiently well established to permit the courts of the circuit to take judicial notice of it in future cases. There is tons of tongue twisting language in these documents. And then we have the highlight on 4. STR analysis is routinely used for kinship analysis, such as paternity. So moving along. The product of the genealogy conducted by the FBI was a family tree that contained the name, birthday, and death date, if applicable, of hundreds of relatives, as well as their familiar connections between each of the other suspect, Bryan C. Kohberger. And this is the first time that we've seen his name, I think we're on page 5 now, come up in this document. The FBI then sent to local law enforcement a tip to investigate the defendant. The IGG process pointed law enforcement towards defendant, but it did not provide law enforcement with substantial evidence of guilt. The FBI did not, for example, conduct a direct comparison between snap profile of the K-bar knife sheath and defendant's snap profile. That type of direct comparison required a more traditional STR DNA analysis, which was conducted by the Idaho State Police, not the FBI. Prior to the FBI's IGG efforts, the ISP laboratory developed the traditional STR DNA profile from DNA found on the knife sheath, K-bar knife sheath. After identification of the defendant, law enforcement recovered trash from a home of the defendant's parents, and ISP laboratory did an STR DNA analysis of items from the trash to compare to unknown crime scene DNA. The comparison indicated the DNA found in the trash belonged to the biological father of the individual who left the DNA on the K-bar knife sheath. And that's giving you kind of how they got there. How did they find this DNA matched? And, we heard a lot about this in the beginning of the case. And when these documents started coming out, how his father's DNA basically was how they came into finding Bryan Kohberger. Pursuant to the search warrant, law enforcement then collected DNA from the defendant via a buccal swab. And this is important to talk about a buccal swab because I know there's been a lot of questions and comments about this. A traditional STR DNA comparison was done between STR profile found on the K-bar knife sheath and the defendant's DNA. Comparison showed a statistical match. So let's talk about what is a buccal swab. Well, this is a buccal swab. This is basically a swab that they use inside of a small test tube, and it looks something similar to a Q-tip that they would swab the inside of your cheek. You're going to put that backside the test tube, and that's basically collecting your cheek swab or buccal swab. So I know there's been some questions and comments about, is this legal? Yes, it is legal. This can happen. Law enforcement has the right to do this in some certain states, and I'm sure that Pennsylvania or Idaho, where this buccal swab was performed, it's probably legal there to do this. So there was a Supreme Court ruling, and this is an article back from 2013. It says Supreme Court rules DNA can be taken after arrest. The Supreme Court ruled on Monday that police can routinely take DNA samples from people who are arrested but not yet convicted of a crime and see if the DNA matches any samples from unsolved crimes in the nation's database. And I know that there's probably been a huge bunch of legal arguments in this. I'm not going to get into all the politics of that in this podcast, but I wanted to just give you a little bit of a background that it is legal to take a buccal swab. Probably in some states, if someone is being accused of a very serious crime. So moving on, we go back to our document here. Specifically, the STR profile is at least 5.37 octillion times more likely to be seen if defendant is the source than an unrelated individual randomly selected from the general population is the source. The genealogy conducted by the FBI resulted in a lead that pointed law enforcement to defendant, but it did not result in the creation of many documents or records. Much of the information relied on by the FBI was only viewed through their user portal in a publicly available GG service and other investigative databases. The FBI did not download or create copies of those records. Once defendant was in custody, the FBI removed the SNAP profile from the GG service pursuant to the United States Department of Justice interim policy for forensic GG DNA analysis and searching DOJ policy. This means the FBI no longer has access to view much of the information it used to create the family tree and cannot be viewed it again without resubmitting a SNAP profile to the GG services. To the state's knowledge, the only record that reflects the FBI efforts to create defendant's family tree is the family tree itself. Notes jotted down by FBI agents as they constructed the family tree and any records created to document to remove the SNAP profile from the GG service pursuant to the DOJ policy. The state has not seen, nor does the state possess these records or copies of these records. So probably everybody's asking, what is an octillion and how big is an octillion? So you can see there on the screen, that's how big an octillion is. And I'll read a little bit from this. So an octillion is an equal to 1 followed by 27 zeros. And this just gives you the grand scale of, we'll go back here. It gives you the grand scale. It says the STR profile is at least 5.73 octillion times more likely to be seen if defendant is the source than if an unrelated individual randomly selected from the general population is the source. They're saying basically this DNA is Bryan Kohberger's DNA. We're going to move on here and see what Peter Tragos, the lawyer you know, has to say about all of this.
But what we know right now is there is no evidence of any prior crimes. And I think we need to remember that as we go through this process. And as they stack up evidence, like it seems to me like they're going to connect his DNA to the knife sheath, and you're going to hear me say that is almost impossible to get over if I'm a juror and I'm sitting there and they have the car stuff, they have the cell phone stuff, they have the pinging. Maybe he follows them on social media. But when they put his DNA on the weapon sheath at the scene of the crime next to the bodies, that's going to be tough to overcome.
All right. So we had Peter chiming in there. And what we're going to do now is, again, I am not a lawyer. There's the argument sense to this document. And what I'm going to do is play up the 20-minute segment of Peter Tragos, the lawyer you know, that kind of explains what the argument here is in this document. So let's pull that up and take a look at it.
So on one side, the state's going to argue, and I don't have a ton of time to get into this, but on one side, the state's going to argue, oh, we have all this technology and we can prove he was here and not here and turned off his phone and his car went here. And this is how we connected his DNA. But they're going to act like it was so difficult to just take a screen grab of your computer as you built the DNA profile and the family tree to see how we went from step 1 to step 10 to connect this to Bryan Kohberger 5.37 octillion times more than anybody else. I like this. William said, in a math class, if you don't show your work, you don't get credit. There's a reason for that, William. Because there's a lot of different ways you could have got the right answer, right? You could have cheated. You could have taken the class before. You could have guessed. And none of those things are good. None of those things are accomplishing the goal of the teacher. The teacher wants to know you did it right and you know how to do it. So it does matter. I know people are not going to like that. All right, let me get to a couple questions here quickly. Chris, does single source male DNA mean that that's the only DNA, or they found a sample that wasn't mixed, but there may have been other DNA on the sheath. It doesn't say whether or not it was the only DNA there. I would be shocked, obviously, if it was underneath, if it was at the scene and we can expect other DNA was everywhere. I would be surprised if there wasn't at least some of the victim DNA on there. But at this point, I don't think we know that answer. The architect. Will the DNA evidence ultimately be admissible considering there isn't enough for the defense to test it independently? Wouldn't that be prejudicial? Yes, and the defense can make those arguments, but I do think it's going to end up being admissible. But that is an argument as far as a fair trial, right? Everybody's arguing against the media. This needs to be a fair trial. Well, let's apply that across the board. Ainsley, thank you for explaining everything. You are the best. Happy Wednesday. Thank you, Ainsley. Going to need to get my voice a rest after this one. Mercy Cat. The chain of custody was corrupt from the time the first LEO in the room didn't see that sheath and subsequent LEO found it. Touch DNA proves nothing. I don't know if it proves nothing, but there will be arguments against it. Beach Butterfly, nice shirt, bro. Like it. Thank you. Available in our merch store. Check it out.
And that's the thing about this case. There's so much complexity every single day that we hear more about this case. And there is going to be tons of arguments all the way up until October. If we think that this case is going to happen in October, I think it's going to be like 2024, sometime early 2024. Again, I'm just speculating at this point, but the amount of information that comes out, the amount of arguments, we have everybody speculating, giving their opinions. There's good opinions, there's bad opinions. It's just crazy. It's crazy to sort through all of this information, but we'll keep playing through here with Peter and just see what he has to say as far as, what's next in this document as far as the argument.
All right. Let's continue with the document here. John, why don't you throw up the new members while I read the argument here? And welcome to all the new members joining. The state seeks a protective order for a narrow category of information, namely information related to the use of IgG in this case. Idaho Criminal Rule 16 governs discovery in the proceedings. Rule 16 is broad, but it is not a free-for-all. The rule contemplates the exchange of discrete categories of information between the state and the defense. As relevant here, the rule contemplates the state will provide 3 discrete categories of information: any material or information that would tend to negate the guilt of the accused, any documents or objects that are material to the preparation of the defense, intended for use by the prosecutor as evidence at trial, or were obtained from the defendant or belong to the defendant, and reports of scientific tests or experiments. If a defendant believes he should receive information that does not fall within one of the discrete Rule 16 categories, the rule allows the defendant to seek an order from the court for information where the defendant can show a substantial need for information in the preparation of his case. How does this not fall into all of those categories, right? Like, come on. Here, the defendant served on the state a request for discovery that calls for the IgG information, even though the IgG information falls outside the Rule 16, without first obtaining an order from this court. The state now seeks, and the court should enter, an order protecting the information related to the use of IgG in this case. So this protective order is not like a motion to seal. It's not so the public doesn't get it. They are filing a motion for a protective order here to not allow the defense to get this information. The state seeks to protect the following information: the raw data related to the SNP profile and the underlying laboratory documentation related to the development of the profile, such as the chain of custody forms, laboratory standard operating procedure, analyst notes, etc. All information related to IgG efforts in creating a family tree and identifying the defendant's potential relatives, including the identities of the genetic genealogy services and the personally identifying information of defendant's relatives. So first, that's what they're trying to block. Here's just what I'll say. This would be the easiest thing in the world for me to say, you have to give it to them if I was the judge.
And they probably will make that motion. They probably will. And I think that's been the biggest controversy in this kind of motion or this argument so far is, everybody goes, well, why are they protecting it? Why are they hiding? Why are they just handing it over?
So that, to me, should be an easy yes. Why should the defense not get this? Now, if you want to do it under seal or, under a protective order so the public can't see it or get it, perfectly fine with that.
Yeah, I was just going to basically get in that, is that the state is looking to say, we need to protect the public identities of, how we trace this along and not put any of that information out there. And the defense is going to argue against that. So let's hear what Peter has to say.
Don't publicize this information, but the defense should get it. You're saying there's not even that many reports. So give them what you have. That's what I would say. The state does not seek to protect and has or will disclose the following information. Has or will. A genotype kit report from the private lab utilized by the Idaho State Police, which documents that a DNA test was performed. Thank you. Information related to the STR DNA analysis conducted using the DNA recovered from the K-bar knife sheath and the DNA recovered from the defendant's parents' trash. That's good. They're going to turn that over. Information related to the STR DNA analysis conducted using the DNA recovered from the K-bar knife sheath and the DNA recovered by the defendant on his buccal swab. This court should grant an order protecting the IgG information in this case because the IgG information does not fit into any of the discrete categories listed in Rule 16, and good cause exists to protect the information, including the need to protect the privacy of the defendant's relatives. So you're protecting the identity of the defendant's relatives from the defendant to potentially not allow the defendant to maybe like point the finger at a relative that the state believes is innocent. What if the defendant doesn't believe it's innocent? What if it connects up very much so with some distant cousin that also went to University of Idaho? I'm not saying that exists, but if it does, seems like that would be important and potentially exculpatory. Obviously, I'm not saying the state's hiding it because they think that, but they've been wrong before. Rule 16 does not require the disclosure of the IgG information because the IgG information is not exculpatory. How do we know? Right? Maybe the defense thinks it is. Rule 16A of the Idaho Criminal Code does not require disclosure of IgG because it does not tend to negate the guilt or reduce the potential punishment of the defendant. The rule requires the state to disclose any material or information in the prosecuting attorney's possession or control that tends to negate the guilt of the accused as to the offense charge or would tend to reduce the punishment. As written, this rule largely mirrors Brady, and the state has to produce the criminal defendant all material exculpatory information. But Rule 16 and Brady are limited to exculpatory information. They do not require the prosecutor to make a complete and detailed accounting to the defense of all police investigatory work on a case. While the question of whether IgG information must be disclosed as exculpatory is one of first impression in Idaho, the courts outside of Idaho have correctly decided that IgG information need not be disclosed as exculpatory. So, first impression in Idaho means they haven't dealt with it in their state yet, but other states have dealt with it, and other states agree with the state. I disagree with the state. And again, funny is the wrong word. Isn't it interesting that when it behooves the state, they say, oh, yes, we need to keep the media out, or the defense definitely wants the media out, so I'm not getting that twisted. But they will make arguments that we need to make sure the defendant's rights to a fair trial are protected. But it's like, but we don't want to give him this information. And if I'm weighing and balancing the importance of this information and keeping it private so he doesn't see his own relatives' names versus if they did something wrong through this process and the defense hires experts to look through it and proves that they did something wrong, then to me, it should absolutely be discoverable. In green, law enforcement used DNA recovered from the victim's nightgown.
There is so much complexities in this case. How you all feeling? Are you feeling the same way? Let me know down there in the comments. There's so much complexity to this case.
To identify the defendant as a potential suspect, then they surreptitiously recovered items from the defendant's garbage that contained DNA and found through STR DNA testing that the DNA in the defendant's garbage matched DNA found on the victim's nightgown. A saliva test then confirmed the defendant's DNA matched the DNA on the victim's nightgown. Defendant moved to compel the disclosure of the IgG information. After an in-camera hearing, the court denied the motion. So maybe at the very least, they'll have an in-camera hearing here. The evidence that is material to the defendant's guilt or innocence is the testing that followed the IgG investigation, which directly compared a fresh swab of the defendant's DNA with the DNA profile collected from the victim's nightgown. It is only this evidence that the people intend to present at trial. The people are not obligated to provide its preliminary search of the genealogy databases for possible matches, which is investigatory in nature and is not exculpatory or material to the defendant's defense. So I will just tell you, I have been wrong before. Shocker, I know. And I have also felt like I am very, very right about things that judges decide in opposition to me. This would be one of those. I'm either dead wrong or I'm just going to disagree with this judge if they make this determination. Because now we're saying full investigation. Let's just pick out parts of potentially the most important piece of evidence. Why not give this to them? Don't let them use it inappropriately. If the defense tries to twist something or lie or commit fraud in how they use the IgG evidence, then stop it right there in its tracks and the judge don't allow it at trial. But why not let their experts look at this to see if something was done wrong, to see if the way that they eliminated other people was wrong, to see if some of the other people that were in the family tree or before they matched up this DNA is also somebody Bryan Kohberger thinks did this and set him up for it. There are a lot of ways that I think I could argue that this could be potentially exculpatory. As this case illustrates, the state is not required to disclose the IgG information under Rule 16 because IgG information the state seeks to protect is not favorable to the defendant on the issues of guilt or punishment. The information provided to local law enforcement by the FBI was nothing more than a tip, a lead for local law enforcement to follow up on, should they choose to. They also want the tips, right? Again, for the same reason, they want the tips.
Everybody wants
the genealogical tip did not prove or substantiate the defendant's guilt. Rather, the tip allowed local law enforcement to focus their investigation on the defendant. I mean, if it helped them focus in on the defendant, that seems like it was pretty important to their investigation. And obtain independent material evidence of his guilt, all of which the state has disclosed and will disclose. Specifically, with respect to the DNA, an STR-DNA analysis found defendant's DNA matched DNA collected on the sheath. To the extent the IgG information has any relevance, the fact that it led law enforcement to the defendant means it's inculpatory rather than exculpatory in nature. Thus, Rule 16 does not require it. So maybe they're saying there's a different rule they can use to say because it's relevant, they should get it. Maybe the defense should do that, because to me, it seems absolutely relevant, because if you want to pick it apart or show why it was wrong or done incorrectly, even being inculpatory or part of the investigation that pointed to the defendant, that is still important. So they're taking this rule, breaking it down piece by piece. Rule 16b-4 does not require the disclosure of the IgG information because the IgG information does not satisfy any of the required criteria. The nature of the IgG is such that its disclosure is not required. The rule requires disclosure of books, papers, documents, photographs, tangible objects, and buildings or places only when they are material to the preparation of the defense and are intended for use by the prosecutor as evidence at trial or were obtained from the defendant or belong to the defendant. So they're going to argue clearly that it's not material to preparation of the defense. That's where I think the defense would have the biggest argument, because number two, they can control this, that they're not going to use it as evidence at trial. And if they make this argument now and then use it as evidence later, the defense can bring this up. But as of now, they're saying they're not going to use it. And obviously they're going to say the IgG information was not obtained from the defendant or belongs to the defendant. So we're going to kind of just skip through this one. Here, let's just read this part, the material to the defense. The immateriality of the IgG information to the preparation of the defense is perhaps best understood by way of analogy. The tip that came from the IgG process is no different than any other type of technology hits that put law enforcement on the trail of a suspect. For example, in Johnson, law enforcement recovered a suspect's DNA from a ball cap left outside the scene of the crime of a bank robbery. Law enforcement ran the DNA profile through CODIS, which resulted in multiple hits, including the defendant. A scientist narrowed down the hits to the defendant, and law enforcement confirmed it was the defendant's DNA after acquiring a swab from the defendant.
I think that's been the biggest argument here on the defense's side too, and we've seen that kind of in the new documents have been released, is that, you know, the first time they ran that through in CODIS, that there was no hits for Bryan Kohberger, and then, you know, they went deeper into this snap testing, and that's how they came up, and that's where the big argument is that if they ran this through the first time, then, and there was no hits, how could this been? And, it took you to go in deeper to figure out if Bryan Kohberger was potentially involved in this crime. And I'm sure Peter may talk about this here. Let's see what he has to say.
The defendant moved to compel the CODIS hits from the government, but the court denied his motion. The court explained the DNA evidence material to the defense was the direct comparison between the DNA on the hat and the DNA taken directly from the defendant. The fact that the defendant was the first identified as a possible suspect based on the database search simply does not matter. Here, the IgG information, like the initial CODIS hits in Johnson, is not material. Moreover, the IgG information, and I disagree with that you can't make arguments off of that. I just objectively disagree. Moreover, and I go back to to other cases where we've seen evidence that seemed so sure, whether it's blood spatter or expert testimony, that then just goes away. Moreover, the IgG information could not support an argument that the defendant, that law enforcement violated his Fourth Amendment rights by engineering a DNA collected from the K-bar sheath into a genetic genealogy service. I agree with that. So we can kind of skip through this. Basically, the fact that they used IgG is not violating his Fourth Amendment rights. But I do think that it could be material to the defense. They did not rely on the IgG information to establish probable cause for the defendant's arrest. They did not present the IgG information to the grand jury. That's new information. And they have no plans on presenting it. And has no plans to present the IgG information for which a protective order is sought as evidence at trial. No surprise there. Third, the documents are tangible objects. The defendant has no property and interest here. To the extent the K-bar sheath once belonged to the defendant, he abandoned it and his DNA. I don't think he's going to make that argument. That was my sheath. You got to give it back to me.
Yeah, that won't be a good thing.
All right. Next section here. Again, I've only got about 10 minutes left, so I'm going to try to buzz through this. Rule 16b5 does not require the disclosure of the IgG information because the IgG information is not the result of a scientific test or experiment. It's not the result of it, right? It gave them the hits and then they did the results later is what they're going to argue. Rule 16 also requires the disclosure of information related to scientific experiments, but it only applies to limited information. Namely, Rule 16 requires the disclosure of results or reports of scientific tests, experiments made in connection with a particular case. The rule does not require the state to disclose what law enforcement does with the results or reports. Moreover, a process, procedure, or investigative technique is not a scientific test or experiment, merely because it involves the comparison of information or objects or requires the use of logic or reason. I don't disagree with the state here. There are two types of scientific tests conducted with respect to the DNA that fall within the purview of Rule 16.5. First, the STR DNA, which they're going to give up. The FBI Rule 16.5 does not require the state to disclose how the SNP profile was used. So they already made that argument. Starting with the potential relatives, the FBI engaged in traditional genealogy to put together a family tree that could lead them to the suspect. Putting together the family tree required the FBI to use resources such as social media, publicly available databases, subscription-based databases, vital records like birth certificates, census records, and historical newspapers. None of these actions are accurately characterized as a scientific test or experiment. I don't necessarily disagree with them. I still think they're discoverable, though, under the other rules. All right. Good cause exists for the court to enter an order protecting the IgG information, and if necessary, the court should hold an in-camera hearing. I think at the very least, the court is going to hold an in-camera hearing. The mere fact that the IgG information does not fall within Rule 16 is reason enough for this court to enter an order protecting the IgG information, and therefore allowing the state to not turn it over to the defense. But the state is not seeking the protection of IgG information as an exercise in obstinance. We're not just trying to block it. We're not just trying to be difficult here, Judge. Instead, the state seeks to protect hundreds of innocent civilians from having their personal information, including their names, birth dates, and familial connections to the defendant in a high-profile quadruple homicide from being disclosed. The disclosure of the IgG information risks harm not only to these indirect informants, they're informants only because they were connected through social media and other databases. indirect informants, but also the genetic genealogy services used by the FBI and the IgG investigative technique, meaning we want to keep that private. We don't want to tell criminals how we do this, or else they'll be able to try to get around it.
Right.
This court should follow the procedure laid out by Idaho's appellate courts to determine whether the IgG information must be disclosed. 1. Providing the IgG information would require the disclosure of identity of informants and prejudice the state. The process used to collect the IgG information required gathering information from several informants, including the genetic genealogy services to which the SNP profile was submitted, and indirectly from the relatives of the defendant who hit on the SNP profile. Pursuant to Rule 16, disclosure must not be required of an informant's identity unless the informant is to be produced as a witness at a hearing or trial. The state has no intent of presenting the IgG information. We already know that. None of the informants will be produced as witnesses. This non-disclosure of this information is consistent with the state privilege to refuse to disclose the identity of a person who has furnished information relating to or assisting in the investigation of a possible violation of law to a law enforcement officer. The reason this is a thing is because we want to be able to catch criminals. We want to protect informants. And if informants give information to the state, we want the state to be able to use that. And if they're not going to rely on the informant's information, and this is important because of how I've kind of been talking about all of this, it is important that if the state wants to use something an informant gives them and then go and investigate and find the actual evidence, they have to turn over the evidence and produce the evidence. They don't necessarily have to produce the informant. It's like saying the informant saying, go look at the video at that 7-Eleven because all of this happened and I bet that video captured it. And if the state goes and looks at that video and it has the video of the crime on it, they have to turn over the video. They have to turn over how 7-Eleven keeps that video, but they don't have to turn over the informant because the way they were pointed to that video is not necessarily evidence. And that's what they're trying to connect this IgG stuff with. Now, the reason I disagree with that is because this IgG stuff is more like an informant saying it could have been any of these places. It could have been any of these spots. And we want to know all the different spots it could have been. That's where I think there's a difference. But I can see the arguments made on both sides. As a general matter, we protect the identity of informants. We encourage the flow of information concerning commission of crimes. Okay, I guess I didn't need to stop and explain this because they're going to explain it here. Such commissions are discouraged if the informant's identity is disclosed. The court's words, written long before SNP profiles were used for investigative purposes, apply with particular force to IgG information. Both the genetic genealogy services to which law enforcement agencies submit a suspect's SNP profile and the customers of those genetic genealogy services who may unknowingly be related to a suspect would be less likely to make their information available if the courts start requiring the disclosure of their information in criminal cases, especially in high-profile criminal cases. Yeah, well, guess what? We as the general public don't want the court to force us producing our DNA. The court retains wide discretion to protect against the disclosure of information that might unduly hamper the prosecution or violate some other legitimate government interest. 5 minutes left and 3 pages. I don't think we're going to get through it. This court should follow the process laid out by Idaho's appellate courts to determine whether the IgG information must be disclosed. Rule 16 allows this court to
say a hell of a marathon here. Well, a hell of a sprint, actually. Peter's doing a great job here. And again, I really urge you to go over, check out his channel. If you're looking for a lawyer's point of view, other than just, us creators or YouTubers, this is someone that knows the law, that's skilled in the law, has a law practice, and can actually read through these and give very intelligent answers as to what's going on, what the arguments are. And that's why I bring these videos up and reference them, because it is important. Again, I'm not an expert in all of this. So when it gets very deep into the trial aspect of it and the arguments, that's why I like to reference Peter a lot. Another great person as well as Emily D. Baker. And I really respect both of these channels. So let's keep playing on here. Hope you're enjoying this video so far. A little bit different from me to do a recorded video versus kind of the live streams that I'm more accustomed to, but we'll try to keep playing through this and finish it up here in a minute.
To enter a protective order for good cause. If the court finds it's necessary to review the evidence in camera to decide whether disclosure is required, the rule itself allows the court to do so. The rule expressly contemplates that in deciding whether to enter a protective order, the court may permit a party to show good cause by written statement that the court will inspect ex parte. If the relief is granted, the court must preserve and seal the entire text of the party statement. Okay, so we have that here. They're going to at least ask for an in-camera review. Yeah, so I think at the very least, they're going to do an in-camera review before they make this decision. And even if the court finds that the IGG information falls within Rule 16, the court should follow the guideposts that Idaho appellate courts have planted in the protection of the informants. The defendant should first be required to establish that the IGG information is in fact relevant to the charges against him. If he can do so, this court should allow the state to present information at an in-camera hearing for the court to determine whether the IGG information must be disclosed. So what they're saying here is, first, force the defendant to tell you why they need this IGG information, how it fits into Rule 16, not just that it could. Fair. But once the defendant does that, the state then wants to respond and say, here's why it doesn't. And then the court needs to look at the IGG information in camera and decide, does it fit the defense's argument or does it fit the state's argument? And then the judge will do what a judge does and make a decision. The judge is going to judge. All right. Judge is going to judge. Conclusion. Based on the above, the state respectfully prays the court to enter an order protecting the IGG information from disclosure as it falls outside the purview of Rule 16. In the alternative, if the defense can establish the IGG information is in fact relevant, the state asks this court to conduct the requisite in-camera hearing. Okay, and that's it. So here's what's important to note. The defense wants this information. The state doesn't want to give it. So now we're at a crossroads. So I think the right decision from the judge is to do what the state just said there at the end. Defense, tell me why you need it. And if the defense can in any way show that this might be potentially relevant or something that they might use or that they think connects to evidence the state is going to use in a way that they should at least get it and get to ask law enforcement questions on it, then I think the judge should then listen to the state's argument, look at the stuff in camera, and if the judge thinks at all that the defense might be able to use this, they should absolutely deny this motion for protective order and compel the state to turn over not just the 3 things that they agreed to turn over, but the other 2 that they wanted to block. My opinion. Okay.
All right. So that was a great little segment there from Peter Tragos, the lawyer you know. Again, a little bit different for me here to do kind of a recorded podcast, but I just wanted to give this a try in the interest of time. I know I've been really late getting this out, and I wanted to get this presentation together for you. So we'll keep, obviously, you know, following the case here. As all these new documents come out, all these new opinions, all these new articles come out, of course, you know, we'll get back to getting on target, getting back on point and following this. If you're first time over here, please make sure to subscribe, go down there, turn the bell notification on. So every time you know that I drop a new video or go live, you will be informed. If you like this video, obviously give it a thumbs up and comment down below. I'd love to hear what you think. Again, I am Bryan. This is episode 13 of the Let's Talk Life podcast, and I will be back soon. Appreciate you watching this, and take care.